Hey guys, let's share. We're going to talk about the affidavit that pertains to the familial unit. Now we're ready to get it released and out, and out to you guys, so we can start getting it filled out and sent in. So this is all about the familial unit. If you've had children taken from you, interference with your familial unit in violation of the Constitution of the United States of America, then that's what this conversation is going to be about. So we're going to be releasing that. If you guys could share, get the information out. Let's get some people on. We'll be starting in just one moment here. Facebook, we're going to be talking about the affidavit that's pertaining to the interference with the familial unit. So this is the next affidavit here. It's ready to be released. So we're going to be talking about the affidavit that pertains to the interference with the familial unit. This is if you've had a child taken from you in violation of the Constitution of the United States of America. That's what this affidavit is going to be pertaining to, everybody. We'll start in just one moment here. Let's let a few more people come on. So this is going to be all about the familial unit and the interference of the familial unit. So if you had a child taken from you guys, we're going to be talking about that affidavit and the affidavit that we're going to be using for that now. So please share if you can. Please share Facebook, TikTok. Let's share. Let's see if we can get a good attendance. This is all about the interference with the familial unit. If you've had a child taken from you, then we're going to be going over the affidavit that pertains to that now. Okay, we're going to be talking about that. That's next affidavit that is ready to be released. Okay, so please share. We'll start in here in just one moment. Let's get a few more people on. We're about to start talking about the affidavit that pertains to the deprivation of the familial unit. When government interferes with your familial unit and the integrity of it, then that would be the affidavit that we're going to go over right now today. All right, it's ready to be released. So let's get started. So Facebook over here, it looks like you guys got a slow connection. I'm sorry, I don't know why we always have a slow connection, but it is what it is. I'm sorry, guys, if I'm going to be choppy on that over here on TikTok. Okay, guys, so last night we uploaded and released the affidavit that pertains to the absence of the indictment by a grand jury. Okay, now I know that it went to Facebook, and it's kind of a pain in the butt. I know that's not what you guys would like done. It's certainly not what I wanted to do, but I didn't know what to do with such short notice because it was too many characters to put into the bio, and and I couldn't put multiple links in. So I just did it just so we could make something happen, so you guys could get it, so we could start getting those affidavits out, start getting it spread around. If you guys have a better suggestion on what to do, I mean, I'm open for suggestions. We have a website that it's going to be on. If there's a jot form it's going to be in, but just to get it out and get it started so that I can start moving. That was the best we could do. But you guys can go into my bio. There's a link to a Facebook post, and within that Facebook post, then you have 3 different hyperlinks. One is to the affidavit for the absence of the indictment by a grand jury. The other is the instructions for it, which includes all the mailing addresses. And then the third is for the actual writ that I submitted last September 29th, 2023 to the United States Supreme Court. That's the one I'm pushing for them to approve and sign, because it only takes one justice to sign that writ, and one of those justices could choose to act honorably, do the honorable thing. Thomas, Sotomayor, Roberts, any one of you could choose to obey the law and just simply sign the writ that you're lawfully obligated to sign anyway. So, but I know that it's not the best way to do it. So if you guys got suggestions, then I'm more than happy to consider them. But you can go in there, download that paperwork. It's 2 pages. All the instructions for how to fill it out is there. Very, very simple. Today we're going to talk about the next affidavit, which is the absence of the interference with the familial unit. So you guys, basically what it boils down to is this, okay? You have a right to have an intimate relationship with your child without governmental interference. And your child has the right to have an intimate relationship with you without governmental interference. Now, that's not written in the Constitution of the United States. It's not enumerated within the Constitution of the United States, which, my issue to the Founding Fathers is that protecting our family unit should have been the first act of our government, not the last. they unfortunately chose to protect their property before they even incorporated or enumerated the protection of our family. Our family is worth more than your property. I mean, that's the greatest treasure that we have here in America, is not our gold or our property or our money. It's our children. That's the only thing that's going to last, be honest. So, my issue is once again, my challenge to them was, why is this the last act of our government? The protection of familial unit. And they've gone and they've done all these other things that are all about advancing the business, and yet we still don't have protection of our familial unit actually written and enumerated within the Constitution of the United States. But that being said, even though it's not written, it was found to exist by the United States Supreme Court in 1984. So, there are rights that exist that aren't enumerated, right? They just exist. And the Supreme Court finds those to exist. It's called incorporation, right? The Supreme Court will identify, yes, there is a right that exists and it's protected by the Constitution. And when they do that, when they make those rulings, that's called incorporating. So they're incorporating something that's not actually written and saying, oh no, this is protected by the Constitution of the United States. So in 1984, Roberts versus United States, the Supreme Court comes out and says, you have the right to have an intimate association with your child. And your child has the right to have an intimate association with you without governmental interference. And that means that it's protected by the Constitution of the United States of America. Now, what's important to note is that they said that it's found to be protected by the First Amendment. That's very important, because the First Amendment are all the rights that are God-given. So God gave you the right to speak. God gave you the right to religion, to have faith. God gave you the right to press. He also made you a mother and father, all right? Because state didn't do it, God did it. And so as a result, it's protected by the First Amendment. Now, the difference between a freedom, because you have the freedom to speak, you have the freedom of religion, you have the freedom of press. The difference between a freedom and a right is that a right was created by man. So man created the gun, right? God gave you the absolute right or the absolute freedom to defend yourself, but how you choose to defend yourself is something that was granted by man. Therefore, we protect those means of defending ourselves through the notions of right and wrong. We want to make sure that everybody within our society has the right to be able to defend themselves through the use of a gun or weapon or arm. And so then it becomes a right. That's why you have the right to bear arms, but you have the freedom to speak. So the child thing in your family unit is that government can't interfere with something that God gave you. God made you a father. God made you a mother. Until the day you die, you're going to remain a mother or a father. Therefore, state can't take it away from you. Therefore, it must be protected by the First Amendment of the United States Constitution. That's what the Supreme Court decided in 1984 in Roberts versus United States. Now, this is very important because when you look at, so regardless of whether it's a firearm or right to bear arms, the thing is that you have the absolute freedom to defend yourself, but the way in which you defend yourself is a right. And that's where it switches. All the First Amendment are all freedoms. Everything after that is a right. So you have the right to bear arms. You have the right to those are not freedoms, those are rights. And so there's a difference between those two. Everything that God gives you is a freedom. Until the day you die, you're going to be able to speak, right? And as a result, it's a freedom. It's not a right. It's freedom. But that's how the Constitution is written. First Amendment are all God-given. They can never be taken away. Until the day you die, you're going to continue to speak. Until the day you die, you have the right of conscience to develop your faculties, become the person that you were meant to be. Those are freedoms to do that, because that's something that God permits you to do through your own self. But the way the other ones are all rights. So your right to indict by a grand jury, for instance, that would be something that man gives to you. But in order for a law to be legitimate, it must be equal and equally applied to all persons across the United States of America. Every single person must have the law protect them. Otherwise, it becomes not a valid law, because laws can't just affect one part of society and not another, because that's oppression. That's not egalitarianism. So the Constitution was all about identifying these things that are so important to the protection of individual liberties, that we wanted to call them out within the Constitution of the United States and make sure that they are never, ever, ever up for contemplation, either through legislative fiat or judicial fiat or whatever. We wanted to make sure that every single person are protected by that. And so when you do say that you have the right to an indictment by a grand jury, because you're creating an obligation for the judge to ensure that it's in place, if you have the right to indict by a grand jury, then that means that every single person within our society must have that or else that's illegitimate. That's not valid. That's in violation of egalitarianism. You're right, they are tyrannical, and that's the problem that we're dealing with. You see, the origin of all the problems that our country is experiencing are two things: oppression and tyranny, right? Now, oppression is the enactment of a law that affects one part of society and not another. That violates the principles of egalitarianism. That violates the constitutionalism that we have in place. Laws, in order to be legitimate, must apply equally to every single person within our society. If a law only affects one side of our society and not another, that's known as oppression, right? Because oppression is the establishment of a law that affects one part of society differently than another. So any law that would be enacted that does not apply equally to all persons within our society would be an act of oppression. Now, the second source of all evil is what's known as tyranny. Now, tyranny is the application of the law unequally by a person in a position of authority, okay? So if you're in a position of authority and you decide, well, I like what this guy's saying, but I don't like this guy. I don't like how he looks, right? Now you become a tyrant now through the fact that you are choosing to apply the law unequally because you're in a position of authority, and you're going to take a side with one party and thus not apply the laws equally amongst all people. That would be a tyrant. That would be tyranny. So tyranny is any person in a position of authority that applies the law unequally amongst the people within society. Now, part of my argument to the Supreme Court is that every single person is entitled to fair and equal governing in the same way that they're entitled to equal protection of the law, right? So you have to have fair and equal governing, because if the government is in place to administer and enforce the laws, then an attribute of fair and equal application of those laws is fair and equal governing. So when government chooses to take a side with one party or another, it is no longer applying those laws equally because it's now chosen a side. And that's the whole basis of all of our argument at the Supreme Court. The whole case that we're arguing is, does the state have a right to be able to judge a case in which the state itself is a party in the cause, right? I mean, in the case of what we're about to talk about with the Child Protection Services here, right? If you have the right to be able to have a relationship with your child, right? And CPS being an agent of the state, right? Because they're enforcing the laws of the state, so they're therefore an agent of the state. They're working under the prosecuting attorney, authority of prosecuting attorney within the county. So they're an agent of the state because they're there to enforce the laws of the state. Therefore, they are part of the executive branch and the enforcement element. So when CPS comes with an accusation against you, right, saying that you're not fit to be a parent, well, now the state has brought an accusation against you of violating state's laws. And as a result, one of the state's agents, one of the body of men that make up the state, is saying that you have done something wrong. Therefore, the judge cannot be presumed to be neutral and biased to act as the decision maker when the same body of men that he works for, the same body of men he represents, is bringing the accusation. Same thing with the indictment by a grand jury. When a prosecuting attorney brings an accusation of a violation of a law, right, that body of men that make up the state has prosecutors, it has CPS, it has judges, it has attorneys. All these people make up the body of men that are the state. So when the body of men that make up the state bring an accusation against you through one of its agents, CPS, prosecutor, whoever that might be, law enforcement, then that judge cannot be presumed to be neutral and biased to act as a decision maker because he has a conflict of interest. He works for the plaintiff. It is a very, very simple jurisdictional error. And it's codified in Article 3 of the United States Constitution, where it says in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. You see, Alexander Hamilton stated in the Federalist number 78, he said that the federal judicial authority of the Union must extend to all cases between a state and the citizens thereof. So if there's a dispute between a state and the citizens within that state, then the federal judicial authority of the Union must extend. The state can't have jurisdiction of a case in which the state itself is a party in the cause. Therefore, the judge has a duty and obligation constitutionally codified in Article 3 to recuse himself because he has a conflict of interest. He works for the plaintiff, the state. And we can look at all kinds of other elements to be able to point to this. Everything is in our favor. Everything. Whether it's United States Code, right? Title 28 Code, Title 28455, that a judicial officer, a judge, has a duty and obligation to recuse himself. That's self-executing. It is mandatory. It is non-waivable if he is an officer of either party. Well, these are judicial officers of the state who is the party in the cause. Therefore, they have an automatic recusal that exists, meaning you don't have to tell them to recuse themselves. He has the duty and responsibility to recuse himself. I mean, if I'm being sued by ABC attorneys and that judge walks in and he realizes he works for ABC attorneys, what's the first thing he has to do? He has to recuse himself because he has a conflict of interest. He works for the plaintiff, right? Well, why is the judge not recusing himself when he walks in the courtroom and realizes that he works for the state and it's the state that's the plaintiff in the cause, right? You're right, they don't. But that's what I'm dealing with here. So I'm dealing with this. We're at the Supreme Court. We're going to litigate this. This has been successfully litigated. The last time was 1793, Chisholm versus Georgia. We're going to do it again. We've got the exact same argument. It's a very, very simple argument, and we're going to win. There's no problem there. So going back to the familial unit, okay? So if the Supreme Court comes out and they incorporate in 1984 your right to have a relationship with your child, such as they did, then that means that it's protected by the Constitution of the United States, and in particular, it's protected by the Bill of Rights. Now, I'm not going to go into anything about the 14th Amendment. You guys can say whatever you want. We're not going to talk about it because we're relying upon it, and it's okay to rely upon it. But the 14th Amendment states that no state shall enact any law that shall abridge the privileges and immunities of United States citizens. Okay? So no state shall create any law that shall diminish, take away, reduce, or abolish any of the rights that are guaranteed by the Bill of Rights. Now, the Bill of Rights are the first 10 amendments. So when it says that no state shall create any law that shall abridge the privileges and immunities of United States citizens, what are the privileges and immunities of United States citizens? Well, we got to go to case, judge-made rulings to determine that. So the privileges and immunities of United States citizens, according to two major cases. One is Corrywell versus Washington. This is George Washington's grandson, Corrywell versus Washington. If you go to that case will identify certain rights that are protected under Article 4, right? But Article 4 doesn't actually say what they are. It alludes to them. It says that the citizens in each state shall be entitled to all privileges and immunities as the citizens in the several states, but that doesn't say what those are. Right? It says that, yeah, if you have a right or an immunity or privilege in one state, then another state can't deny you that because, once again, the laws must apply equally amongst all persons within our society. But you can go to Corrywell versus Washington to identify what those particular rights that are protected under the Fourth Amendment might be. But there was a case in 2019, so a lot of the same justices that we're dealing with right now, right? So in 2019, there was a case called Timbs versus Indiana. That's Timbs versus Indiana. And what was going on there was they were seeking to incorporate the excessive fines clause of the Eighth Amendment. And Timbs successfully litigated it, one, by a unanimous decision made by that court that they stated that the privileges and immunities of United States citizens are at a minimum those enumerated within the Bill of Rights, given their legal effect against interference by the states due to their codification within the Constitution's text. All right, so here's the thing, right? If the Bill of Rights are at a minimum what is protected and guaranteed to every single person as a privilege and immunity of United States citizens, then that means that anything protected by the first 10 amendments would be at a minimum what is the privileges and immunities of United States citizens. So if the Supreme Court came out in 2019 and says, okay, if it's protected by the first 10 amendments, it is at a minimum, what the privileges and immunities of United States citizens are. And then you go to the 14th Amendment where it says that the privileges and immunities of that no state shall create any law that shall abridge the privileges and immunities of United States citizens, then that means that because the Supreme Court in 1984 said that you have a right to have an intimate relationship with your child without government interference, then that means that if a state creates a law that takes away your right to have an intimate relationship with your child without government interference, then that would mean it would be a violation of the 14th Amendment. Because no state shall create any law that shall abridge the privileges and immunities of United States citizens. And then Timbs versus Indiana said that the privileges and immunities of the United States citizens are at a minimum what's in the first 10 amendments. And then 1984, they said that the right to have a relationship with your child is protected by the First Amendment, which is part of the first 10 amendments, the Bill of Rights. So that means that it's a privilege and immunity of United States citizens at a minimum. It's already been incorporated. It's already there. So when a state does create a law that abridges, diminishes, takes away, or reduces your relationship with your child, hinders or obstructs it in any sort of way, that would be an unconstitutional law. So when the state does create that law that thus abridges the guarantees, protections, and immunities of the Bill of Rights and the rights of United States citizens, then what happens then is that that's an act of sedition, right? Because sedition would be the speaking or writing of words, such as law established, in order to cause disaffection to the Constitution to procure its alteration in another unlawful manner. So because the Supreme Court of the United States had incorporated and stated that you have the right to have an intimate relationship with your child without governmental interference, then when they create a law that takes away your right to have a relationship with your child, right, that would be an act of sedition, because now they're altering the Constitution in other than lawful manner, because the edict of the highest court in the land has said, oh no, this is protected, right? So why do we have to keep litigating something that's already been litigated, right? Why do we have to keep going back to the court and saying, wait a second, you said that this was a right that we were guaranteed by the Constitution of the United States. Now they're all being taken away. There's 12 million children that have been removed from their whose relationship has been interfered with by the state, which means that all of those actions of the state are all unconstitutional, because the Constitution protects the interference of the familial unit, right? Because that's what the Supreme Court said in 1984. So when the state does create this law, this seditious law, and then they direct their agents, being a prosecuting attorney or a judge or whoever, that they can take away this right that's guaranteed by the Constitution of the United States under the authority of an inferior state law, well, now you have a crime that's been committed, right? The judge has no authority to be able to take away something that's protected by the Constitution of the United States, because the judges are bound thereby anything in the Constitution or laws in the state contrary notwithstanding. Judge can't take away something that he's obligated to protect and defend, right? So if the Constitution says in Article 6 that the judges in every state shall be bound thereby anything in the Constitution, the key word there is bound. When a person is bound, it means that they have an obligation. One that is bound has an obligation. Now, an obligation can be seen from two different perspectives. From the one bound, the obligation is a duty. From the one entitled, the obligation is a right. So if the Constitution of the United States says that you have the right to have an intimate relationship with your child without government interference, then that means that the judge has an obligation because he's bound to protect it, right? So his obligation is that he must protect your right relationship with your child. That's what he's supposed to do, right? So when he doesn't protect it, then that would be breaching his obligation. And a breach of obligation is also known as a crime, right? And it's constitutionally codified. It's statutory codified. If you have a statutory obligation, right? If you have a law that obligates you to do something, Mr. Judge, right? And that obligation is that you must protect the relationship with parents' children and the children's relationship, then that's what you must do. That's your obligation. So when you say that I can come in and I can deprive you of this right, if I can come in and take away this guarantee of the Constitution under my state authority, well, you just broke the law. You just broke the Constitution, because you, Judge, were obligated to do whatever the Constitution says. And that's called deprivation of rights under the code of law. Any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any rights secured by the Constitution commits that crime. So CPS is an agent of the state. They're enforcing the laws of the state. Okay? They're doing it under the authority of the prosecuting attorney of that county. And so when they come into your house and they say, I'm going to take this child right here. All right? I'm going to take this child. They're now interfering with your intimate association, your freedom of intimate association that was guaranteed or incorporated by the Supreme Court of the United States, protected in the First Amendment. Now you have an agent of the state relying upon an inferior state statute that's going to take away something that they were obligated to protect. And that's a crime. It's a crime that the moment that they take that child without lawful authority, it's a crime that's punishable by death, because that's now kidnapping. So then when they take that child and thus deprive you of a right guaranteed by the Constitution of the United States, the right to have an intimate relationship with your child, right? When they do that, well, that is the crime of deprivation of rights of the code of law. That's the first part of this affidavit. So when an agent of the state, whoever that might be, came into your house and said, I'm going to take your child right here. I'm going to interfere with your intimate association with your family, right? I'm going to interfere with your familial union. I'm going to go against the edict of the highest court in the land from 1984, right? I'm going to war against the Constitution. I'm going to breach my obligations of preserving and protecting those rights that are guaranteed in it because I'm going to rely upon what the state told me to do and not what the Constitution of the United States told me to do. When they do that, that's the establishment of the crime. And anytime you have a criminal act that occurs in pursuance of an outcome by government, that outcome is unconstitutional. It's illegal. Any unlawful act at the beginning cannot become lawful over time or by subsequent legislation. So when the state agent, whoever that might be, came in, interfered with your relationship with your child, right, through government interference, in violation of the edict of the highest court in the land, in violation of the Constitution of the United States, in violation of what God even put into place and established, crime was committed. Which means that everything after that moment is also unconstitutional. But we got to tie in some more people because why not? There's other perpetrators in this crime. So then what happens then is that they took that child, committed the crime, interfered with your intimate association with your child, your familial unit. And remember, it's not just the mother, it's not just one crime. The mother had a right to intimate association with that child, right? The father had a right to intimate association with that child. That's two different felonies. Two different felonies. Then that child had the right to intimate association with his father. That child had the right to intimate association with his mother. There's two more felonies. You have 4 felonies that were committed in that one single act right there. That one single act, 4 of them, right? 4 of them, right? And if they took 2 children, yeah, you have 8. You have 8. These go up exponentially. So every time that they do it, every single person had a right. Because remember, deprivation of rights under color of law, that right to intimate association doesn't just go to the mother. It also goes to the father. And it also goes to the child. And it also goes to the brother and sister, right? If they took one child and they had 2 siblings, there's 2 more felonies, right? Plus another 2 because, so just look and consider the fact that these numbers go up exponentially. So as you guys go out and you start to take these affidavits, you start to fill them out, just remember that it's not one of these. You guys need to fill this out for every single person that's involved. Because guess what? Grandma and grandpa, they also had a right to have an intimate association with that child as well. That was taken away the moment that the government interfered with that familial unit. They can fill out affidavits, right? Aunts and uncles can, cousins, brothers and sisters. Every single person who has lost the ability to have a relationship with that child, every one of them has had a felony committed against them. A felony that, as prescribed by law, is punishable by death. These are serious offenses, you guys. These are, and this is a big deal right now. Okay? So, again, right here, the deprivation of rights under color of law was established the moment that they came in and interfered with something that was already incorporated by the Supreme Court of the United States in 1984, that's already protected by the First Amendment, and they relied upon an inferior state statute to do it, right? The state does not have the power to take action or create a law and then substitute it for the guarantees of the Constitution of the United States, because that would mean that the state laws are more powerful than the Constitution of the United States. We know that that's not the case. We know that. So if the Constitution provides a protection, immunity, a privilege, then that's what all states must adhere to. And if any state decides to create a law that takes that away, that is an unconstitutional law, which means that every time that an agent of the state relies upon that inferior state law that's unconstitutional to produce an outcome, that outcome's unconstitutional. Over and over. Doesn't matter how long it's been done. Doesn't matter how many times it's been done. It is all unconstitutional because it is all deriving from an unconstitutional law. Any law repugnant to the Constitution, any law is contrary to it, is unconstitutional. And it's not unconstitutional from the moment that it's deemed unconstitutional, but from the moment it was created, as though it was never even created, because it was always unconstitutional. Okay? So we can get potentially, we could get 100 million of these, right? Because think about it. You know, most families have had a child taken from them. And every single member of that family can submit an affidavit, because every one of them have had a deprivation of rights, right, by the interference with the familial unit that has occurred against them. All of them. They've all had it. And so that child has the right to have a relationship with his family. But that child was never deemed to be unfit to be a child. Where was that child's hearing, right? Where was grandma and grandpa's hearing to deem that they were not fit to be a grandma and grandpa? What about the aunts and uncles and cousins? Where was the hearing for them? right? That was going to deem them unfit to be an aunt, an uncle, or a cousin. So when government steps in and they say, okay, we're gonna TPR a parental right? We're gonna take away this father's right to have a relationship with his child. Think about the collateral damage that goes around. Think about all the collateral rights that are being taken away without due process, without any hearing. You can never take away a fundamental constitutional right without a hearing. And yet, grandma and grandpa, they never had a hearing. They never had an opportunity to come in and defend themselves and show that they're fit to be grandma and grandpa. And yet the state decided they were just going to come in, take it away through abridging their obligations of preserving it by terminating rights from one single entity. But again, remember, when it comes to the right of intimate association, that goes two different directions. That goes to the child, who has the right to be a child, and it also goes to the father, who has the right to be a father, right? So if you're going to terminate the father's rights to be a father, what about the child's right to be a child? That child has never, ever, ever had due process to remove its rights, ever. Therefore, it lost its right to be a child and have an intimate association with his family without any due process whatsoever, because there was never a hearing done for that child to deem it unfit to be a child. So we have a massive number of potential affidavits that could come forward. Because remember, mother and father, you can file an affidavit for deprivation of rights in criminal law for the interference with the familial unit on behalf of your child, because this is a felony committed in your presence, right? That's all it has to be, a felony committed in your presence. And so when an agent of the state comes into your house and deprives you of a right guaranteed by the Constitution of the United States by relying upon an inferior state statute to do it, that is a felony because it's punishable by death, right? Which is a capital offense, not even an infamous crime. That is absolutely. And so when that happens and you witness that happening, then that means that my child had a felony, that I witnessed a felony that occurred in my presence, and you can fill this out for your child and submit for them, right? And ultimately, what we're going to court and saying is that the state had no authority to be able to do this. State has no authority to step outside of its limited or statutory governing limits and abridge a federal protected rights, because that would mean the state courts are more powerful than the federal court. To what purpose is the Supreme Court then? To what purpose are the United States District Court and United States Circuit Court if the state courts can do whatever they want? I would say that we don't have a federal system anymore. We have a state system. We have a localist system. We have a confederacy, if that's the case. So you see, everything that they're telling us is all bullshit. It's not true. It's contrary to federalism. It's contrary to a republic, right? It's contrary to constitutionalism. And it's contrary to the faith of 330 million people. Because the people don't believe that the states can do whatever they want to do, right? The people believe that states gave up their sovereignty to join the Union and subject themselves to the supremacy of the United States Constitution. That's what they all believe. That's what all of these million people overseas, these warriors and brothers and sisters of mine that fought with me, right? That's what they believe in. That's what they're fighting for. Do you think that they're going to be a little bit shocked to find out that the state courts are able to do whatever they want? They can create their own laws. They can substitute for the guarantees of the Constitution, because the Constitution is nothing. It's nothing. The Constitution might say that you have the right to have a relationship with your child, incorporated by the Supreme Court, but if the state doesn't want to do it, you don't get it. That doesn't make sense, right? The Constitution of the United States might say that you have the right to have an indictment by a grand jury before being arrested and held over for a capital or infamous crime, but if the state doesn't want to do it, then you don't have. That doesn't make sense either. This is not consistent with constitutionalism. This is not consistent with the American principles, beliefs, and so on. So that's where we're at. That's what we're fighting here. So this is the affidavit, okay? We're going to be releasing this again. It's going to go to Facebook, all right? It's a 2-page affidavit. It's very, very simple. It needs to be simple, you guys. It needs to be, because what we're doing is we're building a class action here, okay? Class action. A lot of people are talking about building class actions. Listen, you guys, this is what I do, okay? You know, you can love me, you can hate me, whatever you guys want. I don't care, right? But this is what I do, okay? You guys got to understand that I have a master's degree from the most expensive university in the United States, okay? I have a master's degree in this, substantive law, okay? I got a 3.98 GPA there. I'm tired of the disrespect from people coming in and pretending like they understand something. You guys can listen to me. You can respect the things I'm saying. You guys can get behind this, right? But don't disrespect me, okay? Because I do know what I've been dealing with this particular type of the building of cases, right? The collection of evidence. This is what I do, you guys. I've been doing it for 25 years, right? I've got advanced master's degrees in this. This is what I do, okay? This is what I do. Attorneys hate me because I'm the exact opposite, okay? I deal with law enforcement. I deal with substantive law. I build a case against criminals. And I found who the criminals really are. And that's what I'm trying to do. I'm trying to build a case for all of you so we can overcome the criminality of those that are leading us. Because if I can show that they're criminals, which I can, when I can show that they're breaking the law, the Constitution, then that means that everything that they do is unconstitutional because they're all acting outside of the Constitution. So you guys can get behind this. You guys can say, you know what? I like what he's saying there, right? But what I'm doing is I'm building a class action here. I'm getting a whole bunch of people that have the same procedural situation because that's what a class action is. Every single petitioner must have the same procedural situation, which is why all of this is very, very boilerplate. Everyone, because what's important is not the fact that the CPS came in and took evidence from your house that was not real, or they presented lies and hearsay evidence. That's not what's important, right? That's a diversion. That's a secondary conflict. That has no bearing on what the government did. Because you see, the question that we have, the only question we have is, do you have the right to have a relationship with your child? Yes, you do. It was incorporated by the Supreme Court in 1981. It was found to exist under the First Amendment. Yes, you do. You have the right to have a relationship with your child. Okay, awesome. Did government deprive you of your right to have a relationship with your child? Yes, they did. Awesome. Nothing else has to be said. That's it. Because if you have a right guaranteed by the Constitution of the United States, it doesn't matter what hearsay evidence they presented. It doesn't matter what evidence the judge suppressed. It doesn't matter what lies the prosecutor brought up, because you had a right to have a relationship with that child and government took it away. So the only thing we need to know is, on such and such date, this person portraying themselves as an agent of the state did deprive you or your child or whoever the affidavit is for, did deprive this person of a right that was guaranteed by the Constitution of the United States and incorporated under Roberts versus United States by the United States Supreme Court. That's it. That's the crime. We don't need to talk about anything else. And that same statement can be made by 24 million parents across the country. Because yes, on such and such date of such and such year, some person portraying themselves as an agent of the state came into my house and interfered with my relationship with my child. Now we have petitioners in the same procedural situation. Now we've established the class action, you guys. That's what we have to do. We have to let go of the things that they're wanting you to argue, right? We have to let go of the things that they keep on saying, because when they try to drag you off over here and talk about, oh, the hearsay evidence, or, oh, they're treating me like shit, or, oh, they're lying about me, those don't matter. They do matter. I don't get me wrong, but they don't matter to the fundamental issue. Those are a distraction. Those draw you away from the actual issue. The issue is, did government do something that they were not lawfully obligated to do? Yes, they did. We don't need to talk about anything else. So when we come forward with these affidavits, when you get me these affidavits, what we're doing is we are going on offense, all right? You guys don't have to defend yourself anymore, because when you are defending yourself, right, when you're defending the accusations or the issues that they're bringing forward, that puts you in defense, right? And when you're on defense, that's the worst position strategically to be on. The best position to be on is in the offense, right? Because when you're on offense, you're going to score. So we need to go on offense and not on defense. We need to put government on defense. And we do that by pointing to the criminal act committed by government. Did government commit a crime? Hell yes, they did. They breached the Constitution of the United States. Here's where they did it. I had the right protected by the Constitution. They took away that right. Nothing else has to be said. So we point at their criminal act and we talk about it and only it. Stop letting them distract us by all these other things. And when we do that, we got government on defense. And that's not a place where government can win. They can't, because there is no right to self-defense for a public official. If a public official breaches a constitutional obligation, there is no right to defend yourself from that, because there is no statutory limitations on a constitutional violation, because any constitutional violation is void, completely void, not valid. So if they breach the Constitution willfully or negligently, if they breach an obligation, whether they knew it or didn't know it, doesn't matter. If they breach an obligation, all we gotta do is show that there was an obligation, and that's all that's necessary to avoid all the actions of the government. All of it, it's gone. It doesn't need to get, it's wholly without force or effect on the parties involved in dispute. So that's what we're doing. We're not going to talk about all these other things, and we're going to make it as standard as possible so that we can get 24 million people potentially to fill these out, right? And with 24 million people, do you think that they're going to be able to shut that down? No. But if you guys start talking about what they did to you and your child, if they start talking about, about how they suppressed evidence, if they start talking about how the judge treated you like shit, that is going away from the class. The class has to be in the same procedural situation. And once we get everybody in the same procedural situation, then what happens is if one person overcomes the procedural situation, all persons overcome the procedural situation. So if you guys give me the opportunity to advocate for you, right? You give me the opportunity to go to the court and argue on behalf of these litigants that I'm now going around the country to have filled out for you guys and collect, because this is the case I've been building for 9 years. This is what I do. I build cases and I don't lose. All right. I'm one of the best that there's ever been, guys. When it comes to law enforcement, I'm as good as they get, and they will not get out of this because we have the crime. So if you let me litigate this on your behalf, if you let me hold criminals liable for the crimes they commit, if you come together and you have the narrative that I'm telling you guys to have, stop talking about all this other stuff, stop letting them draw you that direction, come together under one single group, then all that I have to do is show that you had the right to have a relationship with your child and they took that away. And if I can overcome one single procedural situation, any petitioner, anyone across the country, of the 24 million people, if I can make one case overcome it, every single petitioner will overcome it, because every single petitioner has the exact same procedural situation. You had a right, it was taken away by government without lawful authority. Void, everything, gone. It's all out of it. Okay. So the first part here, deprivation of rights. The second part here, that a judge had an obligation to protect the right of intimate association, and he didn't do it. Therefore, he established a conspiracy by and between himself and the CPS agent, and also when the officer who took the child, because remember, CPS can't take the children, right? They have to have law enforcement there. So there's also a law enforcement officer who was present as well, and that law enforcement officer is also now part of the criminal conspiracy as well. So you have three people. You have a CPS agent, right, that deprived you of a right, said, I can take away this child because I think that there's, right? And then you have a judge that says, yeah, I'm going to go ahead and keep this child during the shelter hearing, right? Because the judge had a duty and responsibility to preserve and protect that right to intimate association. When he relies upon the CPS's advice to, judge, don't give that child back. Well, judge, you have an obligation to give the child back because that's a protection and immunity of the United States Constitution. So, when the judge fails to do what he's lawfully obligated to do by preserving the rights protected by the Constitution, then he himself is now depriving of rights under color of law, and he's committed conspiracy to deprive of rights by and between himself and the prosecutor, CPS, whoever that might be, because he is now agreeing to do it in the same manner, right? And so then when you have an officer, law enforcement officer, who's also there, he also has to make sure that what he does is consistent with his authority. He's there to protect and defend every single right secured by and enumerated in the Constitution and incorporated by Supreme Court edict. So there's the scenario, you guys. And so when we say that every single person has had that happen, CPS has come into your house. They've taken your child. They've interfered with your right to intimate association. There's no denying it. The only evidence we need is that on such and such date, this happened. We don't need anything else. It happened. It's actual, valid, real. We don't need any transcripts. We don't need any court documents. It happened. And there's no denying that it happened. That's reality, right? That's the reality. So on such and such date, This CPS officer did come in, deprive me of rights guaranteed by the Constitution when they removed the child from my custody and care. Right? Deprivation of rights of code of law. Then during the shelter hearing, which is the first hearing, right, that judicial officer had duty and responsibility to return that child back and enforce and protect and defend all of the obligations of the Constitution of the United States. When he doesn't do it and decides that he's going to hold that child in shelter, well, he's just established a conspiracy when he failed to return the child to the care and custody of their parents and restoring the familial unit. So, I'm not saying that there's not instances in which children should be protected. But what I am saying is that we better figure out what that is, right? And we better put that into law. Because if it's not written into law, then it becomes arbitrary. And then judges will do it whenever they want. But if the law states that this is a protection of the Constitution, then that means that it's an obligation in all instances. Every single person must have it protected. Everybody. Because that's the rules and principles of egalitarianism. So if we want to change that, if we want to not have our right to have an intimate association or a relationship with our children protected, we want to change that, we can do that. But we need to do that through an authentic act as a people in accordance with the special amending procedure of Article 5. And until that happens, any action contrary to what the Constitution protects would be a criminal act. It would be an act of treason committed by a person who is in a position of authority, who had an obligation by oath or affirmation to protect and defend every single right secured by Constitution and incorporated by edict of the highest court in the land. So that's where we're at. We don't want any more than just that. There's two crimes: deprivation of rights under code of law, conspiracy to deprive rights. Nothing more has to be said. By the establishment of these two crimes, whatever the state has produced, right, whether even if they adopted the child out, that adoption is not valid. Nothing that the state has done is valid because it all derives from a criminal act and a conspiracy established by and between agents of the state. It's very easy, guys. This is very easy. And this applies also to the criminal matter with regard to the affidavits. So, you guys, it's 2 o'clock right now, Central Time. I need to be on a train at 6 o'clock tonight. I'm heading to California now. We released the affidavits for the indictment issue. And here in a few minutes, as soon as I get off this, I'm going to be releasing the affidavits for the familial unit. Okay? With the instructions. I need $300 to be able to get on this train, guys. I need $300. And so I'm going to ask you guys that, again, I do this because it's the right thing to do. I do this because I have the knowledge and ability to be able to help you guys because I can, right? Because I believe in this. I know that this is real. And I know that what they're doing is wrong. And so I'm here to serve you guys. And so I'm going to believe that I'm going to be on that train, right? So I'm going to be down at that train station at 6 o'clock, believing that I'm going to be on my road, out on the road today, starting the collection of these. Starting in California on Monday morning, I'm going to be out doing town halls and collecting these affidavits now. And but I'm going to need a little bit of help to get there. Okay, guys, I'm $300 short on this train ticket. So I do have Apple Pay. I guess I've never really used that, but I'll Apple Pay. I don't know what you need for that. I think it's my email maybe. But I do have Apple Pay. My number through Apple is 843-834-8964. 843-834-8964. That would be my Apple phone number. And then the email address is Tanawah, TANAWAH, last name Downing, DOWNING @gmail.com. That would be my Apple Pay, whatever. So we have Cash App, we have Chime, we have Venmo, we have PayPal. They're all exactly the same. So we shall be free. Okay, we shall be free. I'm not a Freemason. No, I'm not a Freemason. I don't know anything about Freemasonry. I don't follow any of that. So I'm sorry. I don't know if that's good, bad. I don't know, indifferent. No, I'm not a Freemason. I'm not involved in any associations. Okay. So again, what I do is I do it by donation. So we have a little bit of a need financially to be able to get on the train and continue to push forward. We had an awful lot of cost yesterday that wasn't planned. We had to get these evidence bins together with locks and 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 all the paperwork. So, as we start picking these up, this was a necessary evil, but we had to get printers so we could print up these documents. And so as we leave tomorrow or later tonight, we've got about 200 of the blank sheets printed up for the affidavit issue. We've got about 100 of them printed up already for the intimate association issue. We're gonna be doing all of this from the train, you guys. So I hope to be on the train tonight, later tonight, and on my way over to California so that we can start Monday morning with this collection. Okay. Now, some of the things that we're doing, and think about this as well, is that we're trying to lay a bunch of traps for these guys, right? The government's the opposing party. The justice system is the opposing party. So I had a conversation this morning about these affidavits and being sent. And the truth is that yes, the FBI is probably going to be looking into this. They're probably going to try to interfere with this at some point in time. And I'm saying this because if just in case there's ears that are on this conversation that would normally be adversarial, I want them to hear about my thinking. I want them to hear about what I'm about to say here. So if anybody on this live is perhaps from an opposing party, or maybe you don't have the best intentions of being here listening to what I'm saying, I want to say this to the whole group so that everybody understands exactly what's going on. These bins that I have here, they're labeled evidence. It's written across the top, evidence. It has stamps on it, keep out. It's labeled in multiple places. The case is identified, the case number is identified, and it clearly states on the top of both these bins that this is evidence contained within here, and any unauthorized entry into these bins by opposing party would entitle us to any and all civil, criminal, and/or financial retaliation against those acts of aggression. This is evidence, okay? And Mr. Law Enforcement, federal law enforcement, FBI, whoever that might be potentially, you guys are opposing party right now. So if you want to interfere with these bins, then that's going to be evidence tampering because you are opposing party. So we have locks on these, and these locks had better stay on them. And every single thing inside of here is protected and privileged because it is part of ongoing federal litigation against the United States justice system. So let's just make sure that's clear. That everything inside of these bins, you're welcome to X-ray them as we move around. You're welcome to even look at the outside. But if you open these up, I'm filing summary judgment because you're tampering with evidence. Okay, so don't try to go to any one of these location points, these consolidation points, and try to confiscate the affidavits that are coming in. Because if you do that, we are filing summary judgment. Right? We will file criminal offense against every one of you because you guys are opposing party. Right? Any part of the United States justice system, any agent of that, any agent of government is the opposing party as of this moment. So do not mess with my evidence, okay? It's labeled, it's identified. You go into any one of these bins inside the lock, and we will be entitled to any and all civil, criminal, or financial retaliation against those acts of aggression by the opposing party, okay? So leave my evidence alone. Let me capture it. Do not go to any one of my consolidation points. Do not mess with any one of the people that are receiving these affidavits across the country. Because if you do, then just understand that is a crime, and that is going to prove our case. And we will seek summary judgment and financial retaliation against those acts of aggression by the opposing party. So let us peacefully go around the country here. Let us peacefully collect this evidence. Let me peacefully bring it back to DC. And if you want to peacefully concede and avoid what's coming, then you're welcome to do that. Otherwise, let us bring this evidence and do not tamper with it. Do not interfere with it because if you do, then you will prove our case. Okay? So I'll be in DC by January 3rd with at a minimum 500,000 criminal affidavits. And we're going to hit that number easily, guys. We're going to hit that number. I mean, between the familial unit and remember that, it's not just one offense it's not just one criminal affidavit that you guys are going to be able to fill out. Every single family has got potentially 50 to 100 of them, right? Because it's a multi-directional right that existed that was never properly litigated. There was never hearing for the child to remove his rights and prove that he's not fit to be a child. There was never a right for the grandparents to prove that they weren't fit to be grandparents. Every single one of them lost a right that was guaranteed by the Constitution of the United States without due process, because there was never even a hearing to determine that they were not fit to be parent. There was never a hearing to deprive them of the right that they were entitled by the Constitution of the United States. So again, please donate if you guys can. Okay, donate if you can. And I hope that, that in a couple hours I'll be on this train. I'll be out there. You guys, I'm doing this for all of you. All right, I'm doing it for all of you. I'm doing it for my country, and I'm certainly doing it for my own children, because I want to make sure, when I went into this, you guys got to understand that it's been 9 years since I've seen or talked to my children, and I've accepted that for a number of different reasons. One is how can I have a right when so many people around me don't, right? There's another thing that I knew going into this, how dangerous it was, because you guys know my background. A lot of you do. I worked in intelligence, right? And special operations military. I high up in national security. I know how this government works. And the only way I could really protect my own children were, to distance myself from them. Because that's the only way. It's the only way that I could protect them, because I knew what government would do. So it's been 9 years since I've seen or talked to my children, and it's getting very, very hard right now to continue to do it. But that's why I believe in this, you guys. That's why I believe it, because I myself have suffered alongside all of you. It's happened. So, but when this happened, you guys got to understand is that who I used to be before, high up in national security. I was making $870,000 a year, right? I mean, I was the youngest chairman of the National Physical Security Council. I was chairman of the National Transportation Security Council. I was appointed 4 times chairman of the Advanced Video Surveillance Working Group for Homeland Security. I was named the best and brightest in 2015 by the Security Management Institute. I was very high up in that particular industry, but I've come to understand that national security is simply code word for domestic terrorism, right? You don't protect the government from the people, you protect the people from the government. I was on the wrong side. And so when I was woken up and realized that everything I was, everything I had done, everything I had become was contrary to what I was supposed to be, and that I needed to be on the other side, then there came a point in time when I was living incongruent with who I was, right? And I wasn't happy with who I was. So I made the decision a long time ago that if I'm going to be proud of the man that my son becomes, I must first be proud of the man that he emulates, right? So I needed to go out and do something to be that man that I want my son to be like, right? And that's why I do this, you guys. My daughters, I have twin daughters, right? If they're going to marry someone like me, then I first need to be the type of man that I would approve for them. That's why I'm doing this, you guys. I do this because I want to make sure that my kids know what a real man is and how a real man is. I want to set that example for them because this is the right thing to do. And that's why I do this, okay? So I do this for the children. This has always been about children, because you got to understand every single prisoner is someone's child, okay? Every single prisoner is someone's child who was hurt at some point in their life through a system that is acting unlawfully. And we need to heal that trauma and heal, that so that they can become a part of society, able to have long-lasting relationships. And that's why we got to do this. We have to do this because it's the trauma that we're inflicting upon these children through the breakdown of the familial unit, so we can trade this industry on the New York Stock Exchange in the form of Geo Group, Core Civic, and CCNA, and then blame these people who were once children that were abused and hurt, blame them for the things that they do, and lock them away in an institution that enslaves them, and then lies to the people and says, oh, look at the monster that he is. Well, that monster was created, right? That monster didn't just wake up and be a monster. That monster was once a child that someone removed from the loving care of their parents, right? And placed into a foster home, right? Under the authority of the state, where they were molested and forced to work in a... Guys, that's the problem here. That's the disgusting bullshit that we're dealing with. And that's the horrible evil that I will not stop until the day God calls me home or we win. All right? That's what we got to do. That's what I believe in. Right? So help me please get on the road in a couple hours, everybody, if you can. And I can't wait to see you guys out on the road. I can't wait to see you guys out there. You guys are the reason why I do this, because I love my country. I'm as much a patriot as this country has ever produced, but a patriot is one who loves independence of this country. But if you say that you love your country, but then in the same breath can't say that you love your fellow countrymen, then you're not a patriot. right? Because our country is nothing more than an aggregate of people. So how you treat your people is a direct reflection of how you love your country. And today I can honestly say that the majority of these public officials, in fact, pretty much every single one I've met, whether it's a senator, a congressman, a vice president, or a judge, I can say that they are not patriots, because the way that they treat their people, our people, is inconsistent with what a patriot would do. So thank you guys so much. God bless. Please share. I have another live that I'm going to be doing. I'm going to be reading the submission, the writ that we submitted to the United States Supreme Court. I'm going to do that in probably a half hour, you guys. I need to go get something to drink and clear my mind. But you guys come on back in about a half hour if you can. We're going to go over the actual writ that was submitted to the United States Supreme Court last year, September 29th. I want to read it to you guys because this was submitted. This isn't about me. Nowhere in this does it say anything about me, right? Because I did this for all of you. I did this for the people of the United States. I want you guys to hear the words that was written, because I didn't write them for me. I wrote them for all of you. And I know that you guys are going to resonate with the words. So I want to read the actual writ that was submitted, because it's quite powerful, and it's against the slavery institution, guys. So thank you so much. Please continue to share. Please donate if you guys can. I would love to be on that train, and I can't wait to see you guys out there on the road. Thank you guys so much. Together we shall be free. God bless.